rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business in the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. We have about 6.5 hours of oral argument scheduled for today, so I have to remind you to please just ask for the time that you feel you really need. Remember, we have had your briefs and your records, and we are familiar with your cases, so we just need you to hone in on the really important facts and, of course, answer the questions that you will hear from us. In case anybody who hasn't been here before, when I call the case, please, the appellants and the respondents stand up and you let me know how much time each person wants. We'll do the best we can. When the white light goes on, that means you have 2 more minutes. When the red light goes on, that means you should finish up your statement. And if we have additional questions, we will continue to ask them, even if the red light is on. So the first case on the calendar, People versus Janisha Brown. Appellant? Okay. Okay, 5, 2, and 5. Thank you. Barsoom versus Stellar Management. 5, you're the appellant? Okay. Okay, 5 and 5. Thank you. Rosa G versus Hippolito D. Submitted. 1900 Capital Trust versus Guaman. Submitted. Upfront Management versus Thiam. Respondent? Okay, so we'll give you 7 and 2 and 7. Thank you. Padilla versus Whole Rod Associates. Okay, so I'll give you 5 and 2 and 4 and 1. Thank you. People versus KCL. Submitted. Breakaway Courier versus Berkshire Hathaway. No, you don't have a cross appeal, do you? Okay, so I'm going to give you 5 and 2 and 6 for you. Thank you, counselors. Cheeseman versus Cheeseman. Respondent? 7. I'm going to give you 6, 2, and 6. If there's any questions, we'll continue. People versus Jason Williams. Okay. Okay, 4, 1, and 4. Cabral versus Rockefeller University. Okay, and respondent? Do you have a cross? You don't have a cross vote. You do in this one. Okay, sorry. 4 and 1. Can't read my own notes. Lee versus Jun. 2 minutes. Is there a respondent here? You still want to do your 2 minutes even though the respondent's not here? Oh. Okay, you can have 2 minutes. People versus Vincent Lopez. Okay, and responded? Okay, great. 4, 1, and 4. YH Lex Estates versus Mayor. Respondent? Okay, I'm going to give you 5 and 1 and 2. Thank you. And Arch Insurance versus Doc Network. Okay, and respondents? Okay, I'll give you both. I'll give you 6 and 2. I'll give you 5 and 5. I don't know if you'll both need that, but we'll give it to you. Okay, so that concludes the call of the calendar. The first case for argument is People versus Brown. Uh, Excuse me for 1 minute. Could you ask? Yeah. Just 1 moment, please. Thank you. Sorry. You may proceed.
Good afternoon. Karen Brill with the Office of the Appellate Defender for Janisha Brown. Before allowing Ms. Brown to plead to a life sentence for assaulting her daughter's abuser, the court needed to ask even a single question about the connection between Mr. Lawrence's abuse and Ms. Brown's offense conduct. That was needed in order to assess whether Ms. Brown had a viable justification defense of using force in defense of her daughter. The court's total silence requires vacature of her plea now. During her factual...
Counsel, was there any evidence in the record that her daughter was in imminent harm or was even present at the time of this incident?
I think her statement at plea that she intended to injure Mr. Lawrence because Mr. Lawrence was beating her daughter gives that plausible inference. I would agree that it's not totally clear one way or the other, but I think it puts forth that possibility, and that's what the court needed to clarify by inquiring further.
Well, for example, with regard to the Osborne Society letter, which was quite moving, didn't say anything to suggest that the defendant's daughter was present or in imminent danger, which I would have thought would have been something they would have emphasized if that were the case.
So my understanding is that the Osborne reports pretty frequently do not actually discuss the offense conduct itself. They do basically background mitigation, but they don't, go into the offense itself because Ms. Brown hadn't pled guilty at that point, so wasn't going to,
Well, I understand, but I would have thought they would have raised it not in terms of what the offense was, but to give context. Is that beyond what they would normally do?
I mean, I don't know exactly, but I think it was raised in her plea statement. And I think it's a question, right, whether Ms. Brown was credible in her plea statement, but to determine that, the court needed to ask questions about that because her plea statement brought this domestic abuse into the situation. She essentially said that she used force in response to Mr. Lawrence's use of force. That's classic justification. And that was enough under the Court of Appeals in Mox to trigger the court's duty to inquire. And I want to really focus on what Mox requires, because what Mox says is that when someone signals a potentially viable defense, that is enough to invoke the court's duty to inquire into the viability of that defense and the person's decision to waive it. And in terms of, the lack of perfect clarity in Ms. Brown's statement here, that's exactly like what happened in Mox itself. In that case, the defendant said that he had psychotic symptoms on the day of the homicide. He never said in Mox that he had those psychotic symptoms during the homicide itself, and that was still enough to require that court to ask questions. And again, that's exactly what's happened here. She has said that she is using force in response to force. The connection between those two was something that needed to be inquired into. Instead, the court never in the entire colloquy uses the word defense, never uses the word justification, never asked Ms. Brown if she's discussed defenses with her attorney, never asked Ms. Brown if she's aware that defense of a third person, which is not the world's most common defense, existed, doesn't ask a single question about the connection between Mr. Lawrence's abuse and her own offense conduct, essentially just rushes through it. And ultimately, what the Court of Appeals has repeatedly expressed is that pleading guilty cannot be a perfunctory step. Here, what that meant was that the court needed to minimally slow the plea process down by asking Ms. Brown, a woman who had severe mental illness and was alerting the court to a domestic violence situation that was completely absent from Mr. Lawrence's report of the assault, whether her decision to accept a life sentence was informed and voluntary, and in doing so, whether she was knowingly waiving potential defenses. For the court to not do that and to instead do this quick and bare bones plea was an abdication of its duty to ensure a voluntary plea and requires vacatur now. If there are no further questions, I'll save my remaining time for rebuttal.
Okay, you'll have a few moments for rebuttal. Thank you.
Good afternoon, Your Honors. Michael Tarburton for the people.
Well,
Your Honors, the defendants.
Counsel, can you just address this one particular issue for me? Normally, when a plea is taken, one of the questions that may be asked or should be asked is, have you discussed any possible defenses with your client? We can agree that that didn't happen here. And now we have this issue of, well, I was acting because this person was acting inappropriately with my daughter. Does that not cast some kind of significant doubt as to whether or not the plea might have been voluntary or knowledgeable for the defendant?
It does not, Your Honor. The reason being that Lopez's standard, which governs this case, is that the court is not required to inquire further unless the defendant's statement clearly casts significant doubt on the defendant's guilt. That didn't happen here. The defendant didn't say, I poured hot water on the victim's face because he was beating my daughter. She said, I poured hot water on his face and torso because he's he's inappropriately having a relationship with my daughter and beating her. And she said present tense. Now at the time of the plea, she's having this inappropriate relationship. She's complaining about an abusive relationship. She doesn't say anything about the daughter even being present at the time she pours the boiling water on the victim's face. So this is not a case where this clearly casts significant doubt, and that's the standard that Lopez says. To hold otherwise, Your Honors, would be to assume that not only the defense counsel is not doing his or her job, but that the plea court is not doing their job either. I submit that Lopez has the standard for when the record, again, clearly shows that something's gone wrong and that the plea court should be thinking that there's something wrong here. But that standard is not met here. Particularly, Your Honors, when you look at this case in light of the defendant's own version of events. She says to the pre-sentence interviewer that what happened was she hears this recording of her daughter talking to a family member, and the daughter complains that the victim's beating her. So she goes to the victim's apartment, and then she decides to pour boiling water on her face. On that account, there's no indication that the daughter is there, no indication she's in imminent danger of being harmed.
Well, what about the fact that when the sentencing date came, for what I believe would be the third time from the plea till the sentencing date, the defendant then again addresses this issue of the inappropriate conduct by the defendant? Should the court have maybe inquired at that point an opportunity to vacate the plea if necessary?
Well, Your Honors, under Lopez, again, that standard is not met. But particularly since she's already told she's already explained what her version was, and all these statements she makes during the plea and during sentence and everything is consistent with her acting to defend her daughter in the sense that she wants to end this relationship, but not a justification. Her daughter's not there. So the court, I submit, knew what she was talking about. One thing that's significant, Your Honors, is that this statement, the defendant's version explaining why she did what she did, which does not raise a justification defense, it enters the record after the plea, but defendant's claim entirely depends on the notion that you have to presume that the court didn't know about it, didn't know what happened. That's a presumption of ignorance that Lopez certainly doesn't require. The court here certainly looked like she did know what was going on. After all, there's no mention in the paperwork before the plea about the boiling water, which is not a typical dangerous instrument. When the defendant said that's the dangerous instrument she used, the court doesn't bat an eye. When the defendant says, write it down there, I want you to know why I did this, the court said, yes, I'm making note of it. The court at the sentencing says, I thought it was important we put the defendant's position on the record. She knows that this woman is explaining that she didn't do this out of no reason. So she knows what the account is. And she also knows that this is Justice Scherzer I'm talking about. She also knows that there's no justification here. Again, her defendant's complete account of the crime says that not only is the daughter, there's no indication the daughter's there, she's not there. She tells the pre-sentence interviewer that when she hears this recording, which is what motivates her by her own account to attack the defendant, she's not even at the defendant's apartment, she goes there. So there's nothing that indicates justification.
Wasn't there also testimony that the defendant stated that she boiled a bunch of substances together and threw it on his face to indicate that there had been some time that she was thinking what to do? This wasn't an immediate reaction to something that she saw at that moment.
Yes, Your Honor, and that actually was in her guilty plea. That's what she told the court. And of course, the reviewing court is also supposed to look at the allegation against the defendant and read the defendant's statement in light of that. The allegations here is that the victim was sleeping. That's what he said, that he was sleeping. He woke up to her pouring water on his face. And again, what she says is perfectly consistent with that. It's perfectly consistent with her avenging her daughter or attacking him because she's angry about her daughter. But not, there, again, no justification, no indication the daughter's even there. So if there are no further questions, we'll rest on our brief.
Okay, thank you, counsel.
Three quick things. So respondent talks a lot about the standards set forth in Lopez. What Lopez says is that the suggestion of a possible defense is enough to invoke the court's duty to inquire. And then Mox, which came out after Lopez, expands on that and says that when a defendant signals a potentially viable defense, that's enough. And that's what Lopez is
So
describing.
what are you pinpointing in this case that raised a possible defense? What is it that raised that in this case?
So it's that when, during the factual allocution, she is allocuting to the intent, she says that she intended to injure him because he was having an inappropriate relationship with the daughter and beating her. And when you're talking about a domestic violence situation, we're talking about multiple beatings.
What indication is there of immediacy? I mean, a justification defense only exists when you're reacting to something at the moment. What is there in the record that indicates anything about it being at the moment as opposed to that he's generally having inappropriate relations and beating?
I think the indication is when she says it during the factual allocution. If she was explaining her personal, moral motives, the place would have been at sentencing when she's asking for leniency. She's allocuting to the elements. She's talking specifically about the proximate, what happened during that incident, and that's where she says that he was beating her daughter.
She seemed to be concerned that the court would get down her reason for doing this. She said, please put this down in your record too while you're putting everything else down.
Yes, and I think what's important is that Ms. Brown, the purpose of the duty to inquire is to give Ms. Brown reason to know whether what was personally meaningful to her had any legal significance. And I want to be clear, we've never suggested that Ms. Brown's plea could never have gone forward, but there was a question, and all the court needed to do was...
You agree that there has to be a contemporaneous attack by the victim at
There has to be that or the fear of an imminent attack.
Right.
And I think both of those are plausible given her statement. The other thing I wanted to mention is about the boiling. She's saying that she used boiling water when, may I finish my point?
Sure.
That she used boiling water when they're asked what dangerous instrument she used, she says, I boiled substance together. That's not a linear narrative saying, I boiled substance together and then I decided to pour it on him. So we don't know, was there an escalating situation ongoing that she eventually needed to intervene in? Meanwhile, she's boiling water and then decides to use it. That's not clear. And just ultimately, it is not too heavy of a burden to allow one question from the court before Ms. Brown accepted a life sentence. Because of that, we ask you to vacate the plea. Thank you.
Okay, thank you. Thank you both. The next case is Borsum versus Stellar Management. You may be seated. Good afternoon.
I'll remove this for purposes of hearing.
Certainly,
Okay.
whatever you prefer.
Good morning, Your Honors. Basically, the irony of this whole case relates to one simple law, the Real Property Actions and Proceedings Law, Section 768.
Counsel, before
That
we get
tells
into
the
the
whole
merits,
story of this case.
before we get into the merits, how can we possibly make a determination on this appeal when you did not attach to the record the transcript of the decision below? So we have no idea what the reasoning of the court was, since we don't have their decision.
Your Honor, we believe that the record states enough in the record itself.
But it just says it's decided in accordance with the record,
sorry,
and we
Your
don't
Honor.
have the record. So how can we rule on this appeal?
Well, you can do so by reviewing the material that was on the preliminary hearing.
But we have to decide if the court below was correct or incorrect in what it decided. And if we don't know what it decided, how can we decide whether it was correct or incorrect?
this material will show the court how the landlord persecuted this person. Not only was against this person, persecuted this person. For years after year, sometimes it deleted, sometimes it abated, sometimes it didn't, but it was a constant attack against this landlord to try to get that apartment away from her. And very simply, she had a right to it. She was living there with her parents while they were alive. They deceased. She had a right to that apartment. And they initially, the landlord, were collecting rent and then decided to get the apartment back, a higher rent, and have her removed. And what had occurred is, time after time, there were law proceedings. She was held the proceedings went in her direction, but whatever happened, the landlord did things objectively. He started proceedings with other counsel associated with him, saying, in essence, they're starting the proceeding against this person. They don't know who her name is, but for purposes of identity, they're going to use the name of who was really the tenant. In other words, the false, fraudulent machination that tried to take this person, not being a lawful tenant, but being somebody else. And the irony of it is, or the tragedy of it is, the landlord had multiple histories and records relative to the parents, relative to this lady, and did precisely things against her. And this was they brought into this court and that court and every court. Now, some of these courts I was at, but some were preceded by representation of them. But the very bottom line of this matter is, there is no doubt what that record clearly indicates. The landlord had harassed unmissably and was acting in a case of the Property Actions and Proceeding Law, Section 768. It would be as though the landlord took the statute and did exactly what the statute precludes to do as a landlord. And that was the bottom line with this whole proceeding. And this has been going on for several years, stopped, went on. They took her up to another court, and this matter was on and on and on. Finally, it came to a stop. But however, when that stop came, the hearing was by the court below, and the court below, of course, did not take into consideration some of the matters.
We don't know what the court below took into consideration.
I'm sorry, Your Honor?
We don't know what the court below took into consideration.
I know, I respectfully will submit to the court, by way of example, there was
Counsel, we can't get to an example because the court's order says, based on for the reasons stated on the record today, but your record didn't include the transcript of that appearance, so we don't know what the reasons were that Judge Leibowitz stated on the record.
Your Honor, I'm slow, I'm a little hard in hearing. That last comment Your Honor said.
Judge Leibowitz's decision said that he stated his reasons on the record, but you didn't attach the transcript of that day's hearing. So we don't know what his reasons were for making this decision. Is there some reason you didn't attach the transcript?
Well, Your Honor, there was certain representations that are on a record taken out, and the point of the matter is there was a supposed hearing of this matter, and when counsel tried to introduce the fact that the landlord was proceeding against specifically this action, the court below just played negative. Just say, well, I heard you, that's the end of the ball game, in essence. And the bottom line now is we have a case here where someone has been egregiously injured, quotes around injured, not physically, and yet there's nothing being done about it, yet we're being told, get out, you have nothing to do. But the problem is, the record that we made did present enough evidence, enough documents, if you will, to show what had occurred. By way of example, the landlord getting somebody to represent them. That person would come in and say, I'm representing the landlord. I'm not sure I know her name because it's a false tenant, et cetera. It was an absolute house of horrors, time after time after time. Court A, Court B, Court C, no beginning, no end.
Okay, counsel, thank you. I think we understand your points, and we'll take a look at it. We'll hear from your adversary. Thank you.
Thank you, Your Honor.
Your Honors, for the defendants, respondents, Wayne, Desimone, Cullen and Associates, PC. Briefly, Your Honors, as set forth in our brief, there were 3 landlord-tenant proceedings brought.
What's the remedy for the fact that the decision of Supreme Court is not part of the record? How are we supposed to handle review of this appeal?
Your Honor, I think the appeal should be denied based on the fact that there's no record of the team's meeting. There's no, as Her Honor said, there's no rationales given in the appeal.
Was there a transcript made that was available? Did you see a transcript of this hearing that day?
I did not.
Do you know whether there was a transcript?
There was a court reporter.
But you don't know if a transcript was ever made after that team's hearing?
I do not, Your Honor. All of the landlord-tenant proceedings that were brought were meritorious, as set forth in our brief. The action was not dismissed sua sponte, as counsel said, but rather respondents, defendants made a motion for summary judgment. Plaintiff appellant opposed it. We filed a reply.
Were there 2 non-payment?
There were, Your Honor.
When those proceedings were commenced, was there an arrearage in rent payments?
There were in both, Your Honor.
I couldn't hear what you said. There were?
I'm sorry, there was arrearage in both cases, Your Honor. The problem was that the appellant was not properly filling out her SCREE, senior citizen rent exemption forms, and while she was making payments, she was always short.
And when you were paid, you discontinued the proceedings?
Both, Your Honor, both times, immediately. There were never any requests either for attorney's fees or costs in any of the landlord-tenant cases.
And there was also a non-payment proceeding? A holdover proceeding brought as well as the non-payments?
There was one holdover proceeding. The respondent, defendant, neighborhood housing, by the way, brought the proceedings, asked for various documents in order for appellant to succeed to the tenancy of her mother. The appellant refused to turn over the documents. A holdover proceeding was commenced. During the holdover proceeding, appellant did produce the documents. She was given a lease, and the holdover was immediately discontinued.
Okay. Any further questions?
Thank you, Your Honors.
Okay, thank you. Thank you both very much. We'll take another look at these papers, okay? The next case for argument is Upfront Management, Upfront Megatainment. Good afternoon.
Good afternoon. May it please the court. My name is Jeffrey Movitt with the law firm of Mitchell, Silberberg, and Knupp, or appellant. This is a breach of contract action. The plaintiffs allege, my clients, that the defendant, professionally known as ACON, ceased paying a 20% royalty that he's contractually obligated to pay during specified periods when he signed to a, quote, major record label, close quote. The term major label, record label, excuse me, is not defined in the contract. Thus, it's an ambiguous term. The first amended verified complaint,
So how do we deal with the inconsistencies between the first complaint, which seems fairly inconsistent with the allegations in the second complaint?
according to Your Honor, according to the Talking Capital case, the inconsistency is an informal judicial admission, which may be used by the defendant as evidence supporting the defendant's interpretation. But the Talking Capital case says it's, quote, not a basis for dismissal. Rather, the allegations are simply informal judicial admissions entitled to evidentiary weight, but not dispositive, close quote. So there is an inconsistency. Prior counsel made a mistake. The original complaint was not verified. There is no affidavit or sworn statement from my client supporting the interpretation.
You're
in the
acknowledging
first
that they were inconsistent.
Yes, Your Honor, there is. And we respectfully submit that under the Talking Capital v. Omanoff case, it's an informal judicial admission and it's not dispositive as a matter of law. The trier of fact at the trial can be shown the original complaint. My client can be cross-examined about it, and that's what the case law says.
While you state that principle very broadly, its application arises, does it not, because there's an amended complaint, which you have here. So the court has given its imprimatur to there being a different complaint, and therefore it's not a judicial admission, and you get this lesser effect of it. But you have an amended complaint here, isn't that correct?
That's correct, Your Honor. As of right, my client amended the complaint, and the first amended complaint is verified, unlike the original complaint.
Which was not verified.
That's correct, Your Honor. So there is an inconsistency. We submit that the case law is very clear that it's not dispositive, that it should not be dispositive. An error of prior counsel, we should be allowed to make a case to the trier of fact that this was merely an error of prior counsel, that there's a significant evidentiary record that we've...
How should the case argument? I'm sorry, go ahead.
My question was just in terms of the actions of the plaintiff in continuing to make payments under this contract. Does that have any weight in how we should view this amendment?
Yes, Your Honor, it does. In that we submit that as this is an ambiguous contractual provision, major record label is undefined. The sources of extrinsic evidence to interpret that provision include course of performance, Your Honor. And that's expressly alleged that the fact that Akon, the defendant, continued to make payments for about a year after he joined BMG, which is the disputed label, is course of performance. We also have evidence of the intent of contracting party in affidavit form, as well as industry custom and practice evidence in the form of major publications such as Billboard that call BMG a major label, as well as an affidavit from an expert who worked for a prior corporate iteration of BMG, and as she explains the reasons why BMG is a major label.
So why would it be that the plaintiffs, your clients, actually alleged that the term major record label commonly refers to the three large multinationals, Warner, Sony, and Universal? I mean, why would you have taken it on to make that allegation if now you're saying, well, that's not inclusive, it's just an idea?
That was a mistake of predecessor counsel. That's all I can say, Your Honor, without waiving attorney-client privilege, that my client vehemently disagrees with that assertion, and it was made by a lawyer who is no longer representing him, and that we think that there is a very strong record that it is a major label. Obviously, counsel, my adverse counsel, has evidence. She submits the contrary, and we submit that that should be for the jury, but that under this court's precedent, that my client is not bound dispositively by an unsworn pleading that's been amended.
So is there any course of conduct in the industry that would definitively suggest that somebody is considered a major record label and somebody is not? I mean, what kind of, how do you figure that out?
That's what the Harkness affidavit that we attached, Your Honor, goes through. It gives a series of criteria And I see that my light's on, but there's
Well,
four.
that's the white light. You still got a minute.
Yes, so there's four criteria, that they're owned by a global conglomerate, number one, and BMG is owned by a 30 billion euro conglomerate, Bertelsmann, that's major by any standards. Number two, they're global music companies with a diverse portfolio. Here, we put in our papers that BMG is the label for everyone from Tina Turner to contemporary, very popular artists like Rita
Didn't she
Ora.
sell
That's
work, I don't know what, her portfolio of work to BMG relatively recently?
Yes, Your Honor, and that's one of the factors that Ms. Harkness gives in her report, is that a major label has both classic recordings, such as Tina Turner's, as well as new and up-and-coming recordings, such as the pop star Rita Ora. We give an example of her new work is coming out through
So
BMG.
what's your response to the law of the case argument that based on the court's prior holding, you're now barred from making these arguments?
Sure. Well, for this court law, the case does not apply to the de novo
Right, presuming we
review.
would give deference to it, why would it not be applicable?
I would submit that it's a discretionary doctrine, and applying law of the case, and what the judge was effectively doing, Justice Engeron was interpreting the first complaint when he said that this was not a major label. So it's essentially an end run around the talking capital doctrine that says that earlier pleadings are not dispositive when they're contrary, they're just evidence. So if the lower court were to apply its prior summary of the earlier superseded pleading as law of the case, then it would vitiate the talking capital doctrine.
Okay, you'll have a few moments on
Thank you,
rebuttal.
Your
Thank
Honors.
you, counsel.
Good afternoon, Your Honors. Cynthia Arado, and I'm for respondent, the artist professionally known as Akon. The totality of the material here before the motion court made clear that this about-face allegation that BMG was supposedly a major was inherently incredible.
I don't understand why it's inherently incredible. The first complaint was not verified. The second complaint was verified. The decision by the motion court was just on the face of the original decision that said it wasn't major was based on the face of the complaint, and then the complaint changed. So why is that inherently incredible? Especially because of the difference that one was not verified and one was.
Well, I think there's more to this than just the inconsistency, but I don't think it matters that the original complaint was not verified. The statement that BMG was not a major record label was both in the complaint and in...
Did the complaint say that? Did the complaint say that BMG was not a major record label? Or did it just say that Akon was not working with a major record label, which is very different?
It said specifically that the major record label is commonly understood to be Sony, Warner, and Universal Music.
But it didn't say only those three.
It said it was
It said commonly known as, but it didn't, there was nothing that said those were the exclusive.
Well, I think that counsel has acknowledged that there is an inconsistency, and I think that acknowledgement is consistent with the fact that that prior complaint did say, whether it used the word only or not, the only reasonable interpretation of the prior complaint was that it was just those three.
Counsel, what about the fact that the defendant continued making payments under the second tranche, which applies only to if he was signed to a major record label? How should we view that conduct in this context?
In the first motion, the plaintiff argued that the fact that there was a continued payment for about 10 months, which was a mistake, I understand that that's an evidentiary fact, but that conduct meant that we admitted, or it was consistent with us conceding that the payments needed to continue to be made even though Akon was no longer signed to a major record label. They used that fact to support their prior theory and allegation that Akon was no longer signed to a major record label.
In
So
the
I don't
settlement
think
agreement,
it has any...
In the settlement agreement, major record label is not defined, is it?
It is not defined.
So where do we get that definition from? What kind of evidence are we allowed to look at?
I'd say the evidence here, or the allegations in the material properly before the motion court, were both the prior admission, it was also in their opposition brief, not just in the complaint, their own trade, or BMG's own trade organization, the Recording Industry Association of America, says that the major record labels are just Sony, BMG, and UMG. The Copyright Royalty Board, which is the federal agency that is responsible for determining rates that need to be paid by record labels, they repeatedly issue rulings that make clear that it's only the three.
How are you, going back to the first part of your argument, how do you deal with the Talking Capital case, which makes pretty clear that you are allowed to make contradictory allegations and that it's not going to be treated as binding in terms of a later complaint?
I think the Talking Capital case said that a purported contradiction was not dispositive. But it was just a purported contradiction. It wasn't a blatant contradiction like we have here, which was a complete about-face done to thwart the motion court's initial ruling. And we have all the other evidence here. We've got the—
Counsel, this is a motion to dismiss, and that goes to the other points you were making. It's not a summary judgment motion where everybody gets to lay bare the evidence and the court makes that kind of determination. It's a motion to dismiss. So if the term is ambiguous and we have to look to evidence outside of the contract, then that creates a denial of your motion scenario.
I don't think so. I think the material that was before the motion court was properly, you can properly take account of it on a motion to dismiss. It's administrative, it's adjudicative body rulings from the Copyright Royalty Board. It's federal agencies, the Congressional Research Service. It's the Recording Industry Association of America's own statement, which was properly before the court on the motion to dismiss. And there was an admission that has never been explained. And I don't think saying that mistakes were made is an explanation. We don't have the original lawyer saying that he made a mistake. We don't have the appellant saying that they were unaware of the pleadings that were filed on their behalf and the opposition brief. There's no explanation for how this mistake could possibly have been made. All we can see is that there was a complete about-face, which is contrary to the entire, I think, extremely overwhelming showing we have made that nobody says major record labels mean anything other than Sony, Warner, and UMG.
But he did put in an affidavit from someone in the industry that said that there could be other major labels and it was not specifically limited. I mean, I asked that question, how do we determine that? We have some documents that say otherwise.
But they don't say otherwise. What we showed to the motion court and what we have in our papers before your honors is that there's not a single article that this purported expert has provided that actually says BMG is a major record label. They don't say that. They say, they might have a headline that says that, but the body of the article has the head of BMG saying, I want to be a fourth major. He's admitting he's not. So I think it's in our brief, but we've gone through each of those and they actually don't say what the expert claims they say. And so I understand that there's a reluctance to do something on a pleading, but this was an about-face done to thwart a prior ruling. That also was not the case in Talking Capital. And Talking Capital doesn't say—
What troubles me about this is that you're turning this into a dispute among experts, but this is a motion to dismiss on the pleadings, and the first amended complaint says very clearly that it is a major record company. So why are you, I don't understand why we should be looking at other documents.
Because it's not a dispute between experts. The other documents are types of things that this court regularly looks at to interpret contracts in the pleadings. It's like a dictionary definition, a legal treatise. It's an adjudicative body. I mean, we've given you a myriad of information that's not just a competing expert, and we have all of that in contrast to an expert statement that's not supported by any of the underlying material that expert has relied on. And I just want to make one final point about Talking Capital. Talking Capital, we are not saying that just the inconsistency standing alone is sufficient, although I think it could be because it's so stark. But Talking Capital does not say that you can't fold that into the totality of all the material that we have here, which is properly reviewed on a motion, coupled with the fact that there's no explanation for how the prior lawyer, who's a renowned music industry lawyer, could have gotten it wrong, or that the client didn't approve of that strategy when the first pleading was filed. There's no evidence of that at all. I think this was a tactical move to thwart the motion court's ruling, and it's an abuse of the judicial system, and the court's not powerless to halt that, and that's what the motion court did. And I think that the law of case can be applied.
I think we got it. All right, thank you very much for your points. You have 2 minutes on rebuttal, counsel.
Thank you, Your Honors. My esteemed adverse counsel has just conceded that talking capital in and of itself would be not enough to uphold in its de novo review by this court of the dismissal. This is clearly a fact dispute here. It's not a fact dispute that can be resolved at a 3211 stage. It's not just the third-party publications or the expert. As Your Honors noted, there's also course of performance. There's intent by the parties that this is not just a term floating out there in the ether, it's an undefined contractual term. And that's the subject for discovery, for potentially summary judgment, and certainly for trial. It's not a subject for a 3211 motion. With respect to the ad hominem positions, we just respectfully disagree. I don't want to waive privilege, but the original complaint was not verified. My client signed an affidavit saying he very much disagrees with the assertions therein, and now he's carefully reviewed and verified the current pleading. If Your Honor said...
Talking point is not a new doctrine. Maybe it's expressed in a new way, but it cites, is the case Bellatoni, something like that?
Yes, Your Honor.
There was, the concept was there, and it would seem to depend on, perhaps it's verification or not verification, whether it's as a matter of right, or certainly where the court approves the filing of a new complaint, it has been held that what Talking Point says.
Your Honor, the Bogoni case, Your Honor is correct. There's a line of cases. Talking capital didn't come out of nowhere. It's following a line of cases, and the Bogoni case also said that inconsistency between the original complaint and the amended complaint is not dispositive. Rather, it's an informal judicial admission that can be explained at trial. Bogoni also concerned estoppel, and for that reason, the plaintiff lost because there was estoppel issues that are not present here. But Your Honor is correct. There's a long line of cases that Talking Capital is the most recent of.
Okay, thank you. Thank you both.
Thank you, Your Honors.
Thank you both very much. The next case for argument is Padilla versus Holrod Associates. Good afternoon.
Good afternoon. May it please the court. My name is Nicholas Herzler. I represent the appellant Holrod. Your Honors, I think the key issue here, if you look at page 1010 of the record, you'll see paragraph 3 of the lease, which the plaintiff heavily relies upon, because if that section does not apply, then we're out of possession. And the plaintiff is arguing that this was an alteration as far as the work that was done by the tenant. And our point here is that if you look at that clause, and it's entitled alterations, and our point here is that this was just a repair. I mean, as far as the testimony from Liguori and all the other witnesses who know anything about what happened with these stairs is that this was a repair, there was no change. It says tenant shall...
Hadn't someone from your company signed off prior to these two accidents, Padilla's and Alvarado's a few months before, I think, signed off on a license to have the entire stairway removed and replaced?
Your Honor, I think Your Honor is referring to the 2015 permit application. That was 2 years before this incident. First of all, that application is not in the record on appeal, number one. Number two, there's no, as Liguori, I asked questions of Liguori at the deposition about that application. He said there's no indication that any work was done in connection with that permit application.
Well, I mean, there was evidence that I read in the record that a month or two after this accident, the whole staircase was replaced, correct? So there was an application that eventually was acted upon.
It was, Liguori's testimony was that it was too remote in time. First of all, there's a number of staircases. He doesn't know which staircase it applies to. That permit, I mean, the permit's not even in the record, but it was, his testimony was that permit application was too far in time away from the project that was done, that he said in his words, it was unlikely that it would have anything to do with it, and there was no follow-up by plaintiff to try to delve into that anymore. And by the way, that application, it was only signed off by A.J. Clark. That's only the property manager. We're an owner of several condos in the building. A.J. Clark is the property manager for all the owners in the building. So just because A.J. Clark signed something of a permit that's not even in the record, I mean, how does that create an issue of fact?
Counsel, your opposing counsel seems to make, to raise the issue of the Alvarado complaint and the fact that someone else had fallen. Does that matter, notice, does that matter in terms of your position as claiming as an out-of-possession landlord?
It doesn't, because if you're out of possession landlord, it's not your duty of care. It's not your obligation. So even if you're on notice, you don't have an obligation to fix something. And besides, Alvarado, those documents only gave the address of this building. It's a huge building. There are 11 staircases that go from the second floor to the basement in commercial premises, according to unrebutted affidavits that we submitted. So they say there is a problem with the staircase in the building. Okay, you've told us 11 possible places where it could be. Now, under this court's precedents, which we cite, such as Mitchell, Canning, there's the Piaquando case, it has to be, quote, the specific defect in its specific location. Besides the fact that Alvarado fell on a different stair on a different level, but even without getting to that, what relevant, I don't understand what relevance it could be to say, to just tell somebody there's 11 possible places that this could be. And
would it be different if they pointed you to the specific defect?
it could, I don't think it would be, Your Honor, because again, we don't have
out of possession.
We're out of possession, exactly. So, you know, we have a long course of performance from 1983 where this is a sophisticated company. They have their entire construction department. They have a director of construction who I deposed, and they're more than capable of fixing some stairs. There's no evidence that they told us about it. They didn't need to tell us. Everybody involved said, we don't need to know about it. So it's, to us, it's no question of fact. I yield the balance of my time until rebuttal. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court? Kenneth Gorman for the plaintiff respondent appellant. No matter how Holroyd tries to spin this, there are no questions of fact that it had actual notice of this defective condition.
Why does
What
that, go ahead.
If it's an out-of-possession landlord, then what difference does the notice or lack of notice make, unless it was a structural defect or as a condition that it had caused? Neither of which seems to be there's nothing in the record that shows that either of those is the case. So what difference does notice make?
I'm going to argue that this was a structural defect because the entire staircase was defective.
What evidence is there in the record that this is a structural defect? She said she tripped on a chip, basically a chip on the stair.
The entire staircase was in such a state of disrepair that it posed a danger to everyone that used it. 3 people got injured on it before Marisol Alvarado got injured. Marisol Alvarado got injured on it. The plaintiff got injured on it.
What is the evidence in the record to establish that it's in such a state of disrepair? And even so, why does that implicate the out-of-possession landlord?
Because it had actual notice. And there comes a point where when there's a danger on a property that is open to the public, or at least open to every single employee of Quality Meats, and people are constantly getting injured, at a certain point, the landlord has to take action, and in Wright
Well,
versus,
we have a very established body of case law about when an out-of-possession landlord can be held responsible, and you have to fit into the parameters of that argument to make a claim. You can't just say other people have fallen. So how do you fit into our established case law, which we've said many, many times about when an out-of-possession landlord is held responsible? How are you fitting this case into that category?
Wright versus Olympia. In that case, this court held that a lease provision stating that a landlord must approve all material alterations.
But in Wright versus Olympia, the condition that caused the injury was a structural condition. It was the condition of the mezzanine as a whole, which the landlord had approved. Here, there was no evidence that the out-of-possession landlord had approved this staircase, nor would there have been any reason for them to, because it was within this control of the restaurant.
It did. Michael Rothschild, A.J. Clark's property manager, signed the permit application on behalf
There's
of
no evidence.
Holroyd.
That permit application is not in the record, is it? I looked for it. It's not there.
It's not in the record,
So
but at the very...
only the testimony that there is such a document is really of no value to us without the document, is it?
I think the testimony at the very least is enough to raise a question of fact.
No, I don't. I have trouble with understanding why someone's statement as to what a piece of paper says should be of any value to us without the piece of paper, unless the person who himself signed it, but it wasn't, right?
Well, at the very least, it would raise a question that why would the property manager have to sign off on the tenant's application if it was an out-of-possession landlord? That's because it wasn't.
Sometimes owners of a building have to sign off, but even if there was a proposed and ultimate replacement of the stairs after this accident occurred, this accident was not the result of the replacement of the stairs and replacement of the stairs somehow being defectively done. This accident occurred before the stairs were replaced. So what relevance does it have?
At the very least, it should have taken action to cordon off the stairs before it was replaced. I mean, it knew it was a dangerous condition. It knew it. And if Quality Meats wasn't taking any action...
Again, that's not the standard for out-of-possession landlords, that it knows there's a dangerous condition. That's not the standard of liability.
This case is unique. And I think
What makes it unique?
is that everybody knew just how dangerous the staircase was, and that people were getting injured on it. At least 5 people got injured on it, 4 people before the plaintiff's accident, one of which Holroyd had actual notice of at least 40 days before the accident. It was served with process. It was getting sued. I just don't see how Holroyd could be absolved of responsibility under these circumstances.
Okay, let's hear from rebuttal from your adversary, and then you'll have a moment also. Thank you.
I think the court has my argument. I just want to make 2 quick points. The argument that by counsel that the issue was structural is not preserved for appellate review. The argument was not made in the lower court. And to the extent that counsel refers to any other accidents besides Alvarado, let's complete hearsay. The argument was not made in the lower court. Other than that, unless the court has any questions, I think the court understands my argument.
Okay, thank you, counsel.
Thank you.
I don't have anything further unless the court has any questions. Thank you.
Okay, thank you both. The next case for argument is Breakaway Courier.
May it please the court, Christopher Karsich on behalf of Appellant Breakaway Courier. Breakaway respectfully submits that the form selection clause at issue in this case is against public.
Why aren't we bound by our own court's decision in Amazing Home Care, finding that this very form selection clause is enforceable?
Two quick points. Well, one quick point. One, it's a different clause. In Amazing Care, there was no arbitration clause. In this case, there was a significant arbitration clause that they, of course, refused.
But arbitration goes away,
Right.
right? So then you're left with the clause which says that this goes to Nebraska.
Correct. And what I would say in response to that is there's two admitted regulatory violations here. Neither OCRA or Applied Underwriters were licensed to do business in the state of New York. In addition,
But how does that make, for you to be successful in this appeal, you have to somehow distinguish this case from Amazing Home. And that's not a distinguishing factor, that your main distinguishing factor is that this case did have an arbitration clause. So as my colleague said, once there is no longer any arbitration clause, how is this case different from and not controlled by Amazing Home?
well, in response to that, I would say that in Amazing Home Care, the decision focuses on the RPA policy. First of all, the RPA is not a policy. If you look at the RPA, it's a reinsurance participation agreement.
But isn't that the same in both cases? We have the same RPA in both cases, the same,
They're
same
similar.
alleged fraudulent scheme in both cases in terms of the arguments being made about the RPA.
Right. The RPAs are similar, but the Amazing Home Care Court focused only on the RPA. The RPA, even defendants...
That's not actually even true, weren't there also claims in Amazing Home Care that went beyond just the RPA? It wasn't solely about the RPA in Amazing.
Well, I believe it was primarily focused on the RPA policy. Here, but I believe
Well,
that...
I mean, we said specifically in Amazing Care that the plaintiffs in that case asserted 18 causes of action, 14 of which contain allegations relating to the RPA. So that was most of them, but obviously there were still some that were not.
Right, but the RPA, as defendants admit, doesn't stand alone. It's one of the components.
In your complaint, 10 of your 13 causes of action specifically were based on the RPA, and the other 3 were implicitly based on the RPA. So I don't understand why that would be a distinction between that and Amazing Home.
Well, I don't think all these arguments were articulated in Amazing Home Care. The RPA stems from the policies. This is a workers' compensation program that Breakaway is a New York business. It needed workers' compensation insurance. It's statutorily mandated. Applied Underwriters came into the state unlicensed and sold them this program. They got the approved workers' compensation policies.
Would it be unfair to say that your claims concern the agreement?
Which agreement? I mean, it concerns the program. It concerns the RPA. It concerns the policies. The policies, the
And there's no
claims...
dispute that your client signed the RPA, which says that the
Correct.
form selection clause lands them in Nebraska.
Correct. But the regulatory scheme of the state says that side agreements must be approved by the regulators. It wasn't. To allow...
But the regulators could have said, this whole agreement is void, the form selection clause is void, the arbitration clause is void. They certainly could have made that determination, but they didn't. They knocked out the arbitration clause, but they kept in place the form selection clause. So we, as a court, are now left with their determination, which was to keep that form selection clause in place, and that's the structure we're left to deal with.
Well, Your Honor, are you talking about the consent order?
Yes.
Okay. Well, the consent order, it didn't deal with the form selection clause. Those,
Exactly.
I believe the RPAs...
It didn't take it away.
But I think some of these RPAs are different. I believe the one in that case only had arbitration. So I don't believe it had the Nebraska form selection clause. And I mean, that, again, defendants are going to argue that's not binding. The fact is, though, if you look at the consent order, it acknowledges there's violations of the regulation. So how can foreign insurers come into the state, not be licensed, not comply with the requirements, and then say, oh, by the way, we get to go to Nebraska? It's contrary to the entire regulatory scheme for insurance in the state.
Shouldn't that be dealt with by the regulators? I mean, isn't that part of the argument that could have been made to the regulators? Hey, this is a fraudulent scheme. You should, and because the party being defrauded is a New York company, you regulators should handle this and not allow these cases to go forward in Nebraska.
But Judge, how do we
override the contract?
But we didn't raise that to the regulators. We didn't go to the regulators, and quite frankly, I don't think we can force the regulators to do that. They could do that, but we can't file a claim with the regulators. We can't do that. We're left to go to court to bring our claims. Whether the regulators do that or not is beyond our
I
control.
mean, it would appear that the regulators didn't have any problem with the fact that this would go to Nebraska.
Well, it doesn't say that in there.
It doesn't say that, but presumably when they required this consent agreement.
But what if, and Judge, I don't know what the regulators reviewed. What if the RPA they reviewed didn't have a Nebraska clause, it only had an arbitration clause? Then they never addressed this issue. So I mean, you know.
And if they never addressed it, then the contract has to control.
But then how does Breakaway assert its claims when this is an illegal, they did not comply with the regulation? So basically, plaintiffs like Breakaway can't rely on the regulatory scheme of the insurance law then. That's basically what this means then, is that the regulations that you have to be licensed to do business in the state, and that side agreements such as the RPA have to be filed and approved by the regulators means nothing. I think that's the public policy argument, is that allowing this to stand, the regulations have no meaning, as long as the defendant or the insurer puts in a forum selection clause and they get to choose wherever they want to go and force everyone to go there, even though they came to this
Well,
state.
you know about it before you agree to it.
I mean, the forum selection clause was in there once you signed it.
Correct. But then again, the regulations are of no moment.
Okay, let's hear from your adversary, and you'll have a few moments on rebuttal. Thank you, Counselor.
Thank you.
Good afternoon, Your Honor. Shan Stevens for the applied defendants, I'll call them, all 13 of them, or 11, I think I lost track. I will, if you like, just simply ask you if you have any questions of me that you'd like me to answer. Otherwise, I can actually give you a presentation that I have prepared.
What do you have to say about your adversary's public policy argument?
Well, if I get it correct, the DFS obviously was involved in looking at this program and not just one piece of paper of it. They were looking at the program. I was actually involved in responding to them as lawyer for Applied and Accra. They gathered lots of information. They made the DFS. They had numerous policyholders that they discussed their investigation with, and they negotiated with us for several months about what it was they wanted to have in the consent decree, and none of that revolved around the forum selection clause, none of it.
I mean, it would appear that the regulators, for whatever reason, didn't have a problem with the fact that this had to go to Nebraska.
I believe that's correct, Your Honor. And they all, by the way, all RPAs, I can't testify, but.
What about opposing counsel's argument that this case is different from Amazing Home because there was an arbitration clause and the catch-all provision about the form selection only applied if it was a subject matter not covered by arbitration?
Well, I don't think that's what it says. The arbitration clause is paragraph 13. The arbitration clauses appear in 14 and 16. And actually what they say is that Breakaway is submitting to the exclusive jurisdiction of the state of Nebraska, along with its laws, with respect to not only any result of an arbitration, but for all other purposes.
And you think in interpreting that, we shouldn't give any weight to the fact that the reason it's not being arbitrated is because DFS said it can't be arbitrated in New York? That shouldn't affect our analysis at all in terms of a public policy argument?
I don't see why it should. The issue of whether or not it should or shouldn't be arbitrated because the DFS says it doesn't want us to have that clause just means we're not doing that. But 14 and 16, which are the forum selection clauses, are not limited to arbitration results. They simply are not. Their language is not susceptible to that interpretation. I mean, I have them here in front of you, which I can actually read out if you like, but.
We're familiar with the clause, don't we?
Yes, I'm sure you are. This is your second go-around with this. I don't honestly see that there's any difference in these two cases from your point of view, meaning Amazing Home and Breakaway. This particular
Does it
client.
make a difference that in Amazing Home, the form selection clause was in all caps so that the small business people signing it would have had a greater likelihood of noticing it than in this case where it was in small type and not terribly visible or not terribly distinguished?
Well, I would agree that it wasn't in all caps, and that is a difference, but I don't think it's a distinction that matters. The type on paragraphs 14 and 16 is the same as the type in the rest of the agreement, so it's not like it's stuck down in tiny type somewhere that someone would miss it. And here we have a company that has over 300 employees and a $3 million payroll.
They weren't adjudicating this in New York no matter what, because if the arbitration had been allowed to stand, they'd be in the British Virgin Islands, right?
Well, the contract had both those options in it. The first contract they signed said
But
British
not New
Virgin
York.
Islands. What's that?
It wasn't being litigated, it wasn't going to be dealt with in New York.
That's correct. You're absolutely correct.
And in Amazing Home, even if the form selection clause, or even though the form selection clause was in capital letters, I mean, the plaintiffs argued there that the applied defendants never disclosed to the plaintiffs, even though it was in large capitals, that the RPA contained the form selection clause, and we held there that nonetheless, plaintiffs are presumed to know the contents of the instrument they signed and to have a sentence of such terms. We didn't specifically say, and especially when it's in capital letters.
Yes, I think that's right. It was especially when, as opposed to, it has to be in order for somebody to notice it. And not only is this client a sophisticated employer here in New York, they signed this twice, once in 2009 and once in 2012. It's the same person at Breakaway, the president of the company, Mr. Koch, who signed it each time, and he signed it twice in 2009 because there's two places to sign the RPA, and he signed it twice again in 2012. I don't think that there's an issue with respect to whether or not he was somehow misled by the fact that it wasn't in all caps.
Thank you, counsel.
There's a new argument that was made in the reply brief here, and that's one thing I wanted to bring to Your Honor's attention. I'm sure you probably know that anyway, but the very last section of the reply brief makes an argument about Iowa law that they never made in the lower court or in their opening brief.
Okay, thank you.
Just very briefly, it seems now defendants have argued against the consent order having any validity, but now they're happy to rely on the vagueness to say that maybe the court looked at the form selection clause and didn't have a problem with it. Unfortunately, we don't know exactly, but based upon the consent order, clearly the regulators had a problem with this program.
Counsel, all we have is the consent order, though. I mean, he did say things outside the record.
Right.
But we're just going to decide this appeal, obviously, based on the consent order, and all that the consent order says is that the arbitration clause won't be enforced. It doesn't say anything else.
Well, no, it does say a lot. It says a lot of other things, that they violated the regulation.
It didn't say anything about the form selection clause. And obviously, the regulators must have been concerned about the arbitration clause because they got that knocked out, but they didn't say anything about the form selection clause. Can't we take that into account in looking at this?
Well, if the arbitration clause included the form, if it said arbitrations are to be conducted in, like in this case, in the British Virgin Islands, striking out the arbitration clause would take out everything. So that, I mean,
it wouldn't take out the clauses, for example, paragraph 16, which didn't say anything about arbitration and said that matters other than arbitration would take place in Nebraska.
Well, Judge, I honestly don't know exactly what the clauses they looked at. That we weren't involved. My client wasn't involved in that investigation with the regulator. So, but regardless, the
the consent order confirms that this program is riddled with violations of regulations and public policy in the state of New York. So I think it's a stretch to say, well, you know what, they probably would have agreed that it could go to a foreign jurisdiction. It doesn't say that. I mean, but it does say there's numerous violations. I mean, it finds multiple violations with the program.
Okay, thank you. Thank you both very much. The next case for argument is Cheeseman versus Cheeseman. Good afternoon.
Good afternoon. May it please the court, my name is Yonatan Leverett, and I appear on behalf of the defendant appellant. The main issue before the court is not whether the child should have gone to a special rehabilitation program.
Counsel, why isn't this case moot, given that the child has already attended this program? It's already done and gone. I mean, it's all done. Why isn't this moot at this time?
Well, as indicated by the case that's cited by counsel with regard to the fact that I think it's Raz, okay? Subsequent facts can, of course, bar a case based upon mootness, right? But here, the child is still out of school. The child has basically...
We only can look at the record, counsel.
Correct.
So...
But it was an ineffective use of the court's time, and it was ineffective in terms of what the court ordered. Therefore, if it was ineffective and the court didn't hold a hearing on it, it could still be remanded for a hearing to take care of what the child
Done
needs.
already, counsel. There's nothing to have a hearing about. The child's already attended the school. It's been paid for. There's nothing left to be determined. There may be a new controversy coming up about another school and another program, but there's nothing left to decide on this appeal. We don't have advisory hearings on things that aren't an open dispute anymore.
I understand that, Your Honor. But if the court did not hold the hearing, we still have the ability to hold the hearing on what's in the best interest of the child.
Why? Well, the only issue on this appeal, we cannot go beyond the four corners of what's being appealed, is whether the child should attend this program. The child's already attended the program and completed the program.
I mean,
so what would you have a hearing on?
It seems to me that if there was another application to go to another program, that maybe you could request a hearing, but I believe it's my understanding that this child turns 18 this July anyway, so it's unlikely, although possible, that this could happen again. So that we could understand, or I could understand, you might have a hearing on, but what are you gonna have a hearing on something that happened and it's over with?
With child support now going to age 26, and child support including the fact that children can be supported until a much higher age, we have to look at the fact that the child may go to this program in terms of the fact that...
But then wouldn't you have the right to make an application that it wasn't, I mean, I don't know if it was, that it wasn't successful one time or it wasn't the right program. I know that's part of the things that you were talking about in your papers.
Yes.
That there might have been better alternatives. So in the future, but we can't erase what's happened in the past.
No, we can't erase what happened in the past. We could address the economic issues, but those are not as important as where the child actually went. I'll cede the rest of my time. I understand where the court is going. Thank you.
Okay. Thank you. You still have a few moments for a rebuttal if you have anything to respond to your adversary.
Good afternoon. My name is Elliot Weiner. I represent Lenore Cheeseman. I agree with the court that the issue is moot. I agree also with counsel that the economic issues shouldn't be disputed here. I'll answer any questions, but I don't think I have anything else to add with respect to this since it's clearly a moot issue. Thank you.
Okay. Anything further, counsel? No? Okay. Well, thank you both very much. You too. The next case for argument is People versus Jason Williams. Justice Pitberg is recused from this case.
Good afternoon. May it please the court. My name's Elizabeth Vasily, and I represent appellant Mr. Jason Williams. This court should adjudicate Jason, a 17-year-old kid who was sentenced to 11 years, as a youthful offender, or alternatively reduce his sentence to concurrent terms. Given the extensive and unique mitigation in his case, most notably his potential for the future and what we know about youth brain science. Jason was a hardworking college...
Wasn't his background all before the sentencing court?
It was, Your Honor. Nevertheless, this court has the authority to resentence Jason and should resentence Jason, given the unique mitigation in this case.
Well, and in this unusual, somewhat unusual fact scenario, in this case, the judge actually did resentence. So she had more recent information before her the second time than she did the first time, and she reduced his sentence, I think, from 6 years to 5 years, but still ran them concurrently, consecutively. So is there something more that is, I know we have the right to look at it, but is there anything more that's before us now than that was before the Judge Bybin when she did the resentencing a few years after the original sentencing?
That's right, Your Honor. There is, of course, no additional information now on appeal, but this court should still look at this case, that a 17-year-old...
Well, a central point of your brief is that this was a revenge shooting, but yet the defendant, according to the pre-sentence report, says, page 6 of it, he really did not know the victim. How does that square with your assertion that this was a revenge shooting?
Your Honor, the pre-sentence report says he did not know the victim. He was bullied as a child. I think no means not friends with.
He was bullied as a child. I mean, the shooting takes place when he's 17. Is the pre-sentence report referring to him as a child when he's 17? Is that how you're saying this should be read? That child refers to a 17-year-old?
Your Honor,
when you say he was bullied as a child, in a different place in the pre-sentence report, it's a defendant Williams stated that he was raised in a two-parent household and reportedly had a good childhood.
Your Honor, the pre-sentence report is only a couple pages of what has been hundreds of pages of mitigation that we've put forward to this court. And he could have had an overarching good childhood, but still, we put forth...
So you put forth an impressive number of letters from, I think almost all come from school personnel, which are, the shooting takes place on April 11, 2017. The defendant is arrested on April 16, 2017. And a lot of those letters are like written in and about that date. Those letters seem to be, it would seem like they must have been aiming to affect what's done about bail.
If I may.
Sure, go ahead.
Your Honor, those letters raved about Jason's reputation, whether they have to do with bail or whether they have to do with his potential. And he was a college-bound teen. He had a high school diploma. He was accepted into colleges. He was getting good grades.
It's true that they paint a glowing picture of the defendant, and apparently his family must have been very involved in what must have been a charter school. His grandmother was president of the parent body, and one of the writers credits her as being an important part of the founding of the school. How do you square the fact of all of these glowing things that are said about the defendant and the fact that I think it's uncontroverted that he was in possession of the gun for an hour before the shooting and then goes and shoots the victim. There's just such a disconnect between this glowing picture that he's a leader, that he's always helping everyone, he's a great student, and yet at the same time he's in possession. It's not like he just suddenly, there's a certain premeditation in having that gun for an hour before the shooting.
Your Honor, we do not dispute that Jason made a mistake that day. He was under a lot of peer pressure from his friends who were egging him on. He was led by an older boy to the scene who led him. He was following behind him. And we don't dispute the seriousness of the defenses. But that being said, for a 17-year-old child with no prior convictions, who's meant to go to college, who has all of this potential, the goals of penal sanctions are not being satisfied by keeping Jason in any longer. Every extra year that Jason is incarcerated removes him from his community, from his chances of ever realistically going to college. And we get to look inside that he's been ticket-free with no disciplinary history for almost 2 years, and it's shown that he has been rehabilitated. And this court has the opportunity to give Jason a chance at life, and that's why we treat youth sentencing differently than adults, because youth brains, at that time that he made those mistakes, that he succumbed to peer pressure, his brain was not fully developed. It is now, and he's not the same kid that he was then, and that's reflected by science, and that's reflected by all of his progress since then.
Okay.
I understand that I'm out of time. Thank you.
That's okay. You were answering a question. You'll have a minute to respond after we hear from your adversary. Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the court. Robert Butlin for the people. A lot of what I was going to address was...
What was the people's offer on this case?
So it looks like there was an offer for 10 years on both the burglary charge and then a separate offer of 10 years on the attempted murder charge. There's some minutes in the...
Those have been consecutive or?
It's not entirely clear from the
concurrent?
record, but I believe that they would have been consecutive, just like the sentence.
So the people were seeking 20 years, because as you read the plea minutes, the Judge Bybin offers 10 years, the district attorney wants, I'm not sure if it's 10 or 11 years, I don't recall. The DA is asking for that, and Judge Bybin says, well, I'll give you 5 years on it if you plead to the top count.
Yes.
That's talking about the attempted murder.
Yeah, I believe that is the case, Your Honor. And then there was a separate discussion about the burglary charge, which I think was at the original plea proceeding, where the prosecutor working on that also said that the people's offer was originally 10 years, but that was, of course, reduced to 6 by the court.
So the defendant also pled guilty to conspiracy, is that correct?
Correct, Your Honor.
So what was this conspiracy about? Because as you look at the indictment says the conspiracy started in November 26, 2015, and there are other shootings that are set forth. What was the nature of the conspiracy charge against the defendant?
Your Honor, it appears to be limited to just this shooting, and the record on appeal is pretty limited, of course, because the defendant chose to plead guilty. But again, it is still limited to the shooting, but the shooting alone and the nature of that crime warrants the sentence that defendant received here today. Of course, this is an attempted murder conviction. He was facing a maximum of 25 years on that, another maximum of 25 years on the attempted burglary, and yet received only 5 on the attempted murder charge and only 6 on the burglary.
But the people weren't claiming that this defendant had any other role in the conspiracy, other than the shooting.
I do not believe so, Your Honor.
I mean, was this indictment some sort of an indictment against a gang that you have? There are a lot of people named in this, and
yes, Your Honor, it was against the Chico gang. So, of course, there also was, defendant was previously indicted in this case, and then there was a superseding indictment whereby defendant was added with all these other defendants who were all members of the Chico gang, sort of to just show that this was part of this grander gang war between the Chico gang. Oh, yes, Your Honor.
Well, the defendant makes the point that this was a revenge shooting because he had been bullied by the victim.
Yes, Your Honor, I was going to address that. There's absolutely nothing into the record to suggest that the bully was one of the targets of the shooting or the victim of the shooting, as defendant alleges. There's just no support for that in the record. As it was addressed earlier, there was a fight, and the defendant held onto the gun and it stands to reason that the revenge that he wanted to get even for, as he stated in the pre-sentence report, was for this fight earlier in the day. Unless your honors have any further questions, we ask that you affirm. Thank you.
Thank you, counsel.
Counsel, was there evidence that defendant was a gang member?
There was not evidence that he was in the Chico gang, Your Honor. This case has every hallmark of youth brain science. And Jason did not go out solo and do this attempted murder and the burglary. There were 6 people in the burglary case, and there were other older boys as well in the shooting. And so this is every example of peer pressure. And if it were differently, if Jason was himself going out and doing this. And 6 years is a significant time to punish Jason in these formative years. This isn't a probationary slap on the wrist. This is significant time that he spent a fourth of his life incarcerated. And to give Jason a chance at life, he could attend college if he were 23 or 24, but if he completes the sentence near 30, that's looking a lot less likely. And I think that society and the justice system and everyone wants Jason to succeed. They don't want all these talents to go unspoken for. I see I'm out of time. Thank you.
Okay, thank you. Thank you both. Cabral versus Rockefeller University. Good afternoon.
Good afternoon. May it please the court. My name is Eric Berger from Cozen O'Connor, and I represent Rockefeller University and Turner Construction Company in this appeal. Essentially, we're appealing, seeking the reversal of the dismissal of our second third-party claims against Northern Tool based upon contribution and indemnification. The allegations we would submit are adequate to sustain a claim for both contribution and indemnification. Contrary to what the underlying court said, and of course the review is de novo based upon the 3211A motion, we alleged, beginning on page 94 of the record, not just strict liability causes of action as against the distributor Northern Tool, but negligence causes of action as well. Failure to warn, breach of warranty, failure to provide adequate safety instructions. So the complaint is detailed. This is an amended complaint. We further elaborated on a lot of the facts that we were alleging, and we did not just allege a derivative claim of strict liability, but we alleged causes of action for negligence. And in fact, the Court of Appeals has held, with respect to CPLR 1401, which deals with contribution, nowhere is it required that the liability be predicated upon negligence. So even if we just sued based upon strict liability, we'd be permitted to. That's the Downdalakis case versus Town of Hempstead, 42 New York 2nd, 440, 1977.
Well, the court granted summary judgment to the plaintiff against your client on 241-6. There's no 240 subsection 1.
Correct.
Right? And there's no 200 causes.
Correct. Those were.
So this is a statutory, vicarious liability.
Right, based upon the finding of liability as to 2 interrelated industrial code
You still have
subsections.
negligence claims against you, too. Those weren't dismissed, isn't that? Don't you still have negligence claims being asserted against you, your client?
Common law negligence
Common law
claims?
negligence?
My understanding is common law negligence was dismissed with 200.
So, but it's your point that notwithstanding that 241-6 summary judgment for the plaintiff on, you can still seek common law contribution and indemnification.
Absolutely. Absolutely. The law allows for it on both fronts. We've alleged adequately, and with respect to indemnification, it's a statutory violation. And we have a similar case against Prince Manufacturing, who manufactured the piston, and we're bringing a similar cause of action against Northern.
But this, Northern is the distributor as opposed to the manufacturer, right?
Correct, Your Honor. No other questions. I'll cede my time.
Okay, well, let's hear from our adversary. Maybe we'll have some more questions. We'll see.
Good afternoon, Your Honors. Thank you for your patience here today. It's our position, the Northern Tool defendants, that the causes of action for common law indemnification and contribution were properly dismissed. The court below, as the court references, there's a unique procedural posture to this case because the case was 5 or 6 years old before it occurred to Turner and Rockefeller to bring my client into this case.
Won't be the first time, won't be the last time I've seen that, but.
I understand.
And it was severed, right, from the main?
It was severed, correct. And is proceeding separately on the 2 remaining causes of action for which we are cross-appealing here today, which are the contract causes of action. And the argument on our contract causes of action, which the court declined at that time to dismiss, are that there is no contract. They can't show a contract.
The contract claims in the amended complaint were identical to the contract claims in the previous complaint on which your motion to dismiss was denied. So why wasn't your motion to this court, to the motion court here, really a motion to re-argue the prior decision? And of course, we can't hear an appeal from a denial of a motion to re-argue.
Well, the court, respectfully, the court below had two opportunities to review those claims and decided not to dismiss them at this time. It decided for some reason to give the third-party plaintiff an opportunity to try and find these contracts that it hasn't found in the last 7 years. And so we respectfully thought that the Honorable Justice got it wrong, especially in circumstances where their claims are based upon indemnity, which must be strictly construed, and third-party beneficiary, which must have very specific language. And they can't even cite to the contracts because, frankly, there are none.
And what about the contribution causes of action? That's different.
So the contribution causes of action are different.
We don't need a contract for that.
That's correct. That's common law. And the court, because the court was at the same time making a ruling on a summary judgment motion, it had a well-developed factual record. And so the court actually made its determination that they acted negligently. Whether or not the statute is a vicarious liability statute, the court found that they were actively negligent in failing to supervise and review and prevent this accident, this tragic accident. And in that instance—
Counsel, that the negligence claims were dismissed as against Rockefeller and Turner?
I don't believe so. I believe that the remaining claim is based in negligence, and that the court found that Rockefeller and Turner were negligent. And so that case is going to go to trial on the damages for that negligence. That determination has already been made. Beyond that, however, Your Honors, there's no credible allegation that my client, Northern Tool—
Isn't it going to trial on damages on the summary judgment on 241-6?
That's correct.
So, I mean—
And I believe negligence. It's my understanding that there's a common law negligence.
It wasn't summary judgment on negligence.
It was not summary judgment on negligence, but the court did make a finding of fact that they were actively negligent, which precludes them from seeking contribution. Yes.
The court made a finding of fact that they were actively negligent?
Yes, Your Honor.
I have just one more question. Why can't you seek contribution if you're negligent? Contribution is among negligence.
Look, contribution, yeah, actually, excuse me, I misspoke. I was referring to the indemnification claim. Yes, the contribution claim, as a distributor, my client can only be strictly liable, okay? And that's what the court found. The court found that the well-developed record established that my client is a seller and supplier, not a manufacturer, and nobody contests that. And nobody can say a single thing that my client did actively wrong beyond selling this product. And in that instance, contribution is not available under New York law. Thank you.
Okay, thank you. So counsel, let me ask you a question. How, you have a contractual indemnification claim against them? Is that what you're asking, or for a common law indemnification?
So the third-party action requests everything. It requests contribution, common law indemnification, and contractual indemnification.
But we have quite a variation between what the two of you are telling us, because you say the negligence was dismissed, and he says that the Supreme Court found that you were negligent.
Well, it's not his case, and I don't want to cast any aspersions, but
I'm
this
sure
is what I
that's
do.
I'm sure it's an innocent mistake by
Yeah,
someone,
and
but maybe you can
It
clarify.
was my motion, and 240 and 200 common law negligence were dismissed. There is summary judgment as to 241-6, which is a statutory violation.
So,
There's no negligence
The
pending.
ruling actually was that the 200 claim was dismissed, but the common law was not dismissed.
I am not aware of a common law negligence being treated any differently from 200.
I mean, normally it's not, to be honest.
Right.
But I
It's
thought the
a
understanding was that
codification.
it was in this case.
I do not believe that's the case. It might be silent as to
yes,
quote.
that's what, and, well, why would your clients have a contract with the distributor? Why, I mean, I don't even, how could you have a contract with the distributor?
So there would
Under what circumstances?
So there would be, no, that's not what we've alleged. What we've alleged is the subcontractor, New York City Constructors, who was
Right.
responsible for creating this
That was
entire...
that was the plaintiff's employer.
Correct. They purchased the piston and the cylinder that the piston was housed in from Northern Tool, which is manufactured by Prince. So there should be a contract, a purchase order, something that would contain indemnification.
Which might inure to your benefit?
It might absolutely, if there's privity,
I
absolutely.
mean, that's what you would hope to prove, that
Right,
there's
and that's-
something in that purchase agreement that makes you a beneficiary of whatever indemnification was.
That's what we're
agreed to
hoping
there.
exists. So
I mean, if there was a finding that you were actively negligent, that might affect what we should be doing as to contribution and indemnification here. But it would be a surprise that Supreme Court would have made a factual finding of active negligence on your part. At the same time, it was finding you 241-6 liability.
Right.
But you are assuring us that there was no such finding.
That's right.
If at all, the court was silent on the common law negligence claims, which could happen, although they're usually like this with the 200.
I mean, we attorneys read these things very fast, the decisions, but you might be right, Your Honor. They might just not have spoken specifically and said common law negligence.
But the court didn't find you negligent. I mean, the court didn't go to that step and find that you were negligent under common law negligence. They found that there was a 241-6 claim.
Correct. That's absolutely correct.
And what we're talking about is you being allowed to plead this, and if there is a finding of negligence later on that may affect what you can recover in terms of contribution and indemnification.
Right. We're trying to draw from another potentially liable party for which we'd like to take some discovery, even though the case is severed.
Okay, counsel, you have 1 moment to respond.
So the Supreme Court stated, any liability by Northern Tool in this case will therefore not be based on negligence, but by imputation of law. And for that reason, no cause of action for contribution lies against Northern Tool. Again, the court was in a unique situation when it made its ruling, in that it was not just looking at the four corners of the second third-party complaint. It had a fully developed factual record before it. And so the court had discretion to not give credence to bare conclusory allegations that were contradicted by the record.
In that court's decision, did that term negligence need to be defined further, or was it sufficient the way that it was written? I mean, does it explain, because I think we have questions about the common law negligence, and it's just saying negligence. It doesn't say anything beyond that.
Right. The court did not make a finding that a legal claim for common law negligence was established. I want to be clear not to say anything misleading to the court here today.
Okay, well, thank you very much. We'll take a further look at this.
Thank you so much.
Have a nice afternoon, both of you. Lee versus Jun, Appellant has 2 minutes.
Good afternoon, Edward N. Gewirtz of Bronstein, Gewirtz, and Grossman for the appellant defendant. Since my adversary is not here to argue, I simply would like to answer any questions if the panel has, and if not, then I'll rest.
Anybody have any questions?
Okay.
Okay, so I think we're okay, and
Yes.
thank you for coming
Thank
in.
you.
And we will make a decision on the papers that before us.
Thank you.
Have a great afternoon. Thank you. People versus Vincent Lopez. Good afternoon.
Good afternoon, Leanna Duncan on behalf of Vincent Lopez. May it please the court. Your Honors, Mr. Lopez is exactly who is intended for a downward departure. Mr. Lopez endured an upbringing that was replete with trauma. Beginning at the age of 6, he endured physical abuse, sexual abuse, ACS involvement, a parent who struggled with addiction, and at the age of 13, he attempted suicide. This trauma exacerbated Mr. Lopez's already severe cognitive delays. When Mr. Lopez was 21 years old, he committed a serious crime which he takes full responsibility for and has expressed an immense amount of regret for. Since then, Mr. Lopez has done everything in his power to address the issues which led to the underlying offense. The risk assessment instrument did not and could not adequately account for that. During the 7 years that Mr. Lopez was incarcerated, he participated in several different programs ranging from sex offender treatment program, mental health counseling, substance abuse and alcohol treatment, as well as aggression replacement therapy. The clinical notes from these programs indicate that Mr. Lopez was a highly motivated and actively engaged participant in these programs. These clinical notes satisfy the second step in Gelati. With regard,
What was so exceptional about Mr. Lopez that we would consider a downward departure? Now, my second question is, even if we were to agree with you, the seriousness of this crime, how does that factor into it?
Your Honor, Mr. Lopez completed 4 months of the sex offender treatment program, which I know the prosecution raised an issue about Mr. Lopez not completing the treatment. However, Mr. Lopez completed 4 months of that treatment program, and after that, he was transferred to a residential treatment program for mental health issues. Thereafter, the clinical notes indicate that the program was temporarily closed. So although he only did complete 4 months of this treatment program, he still was discharged with a satisfactory level, which according to the DOC's guideline—
Is satisfactory exceptional?
Satisfactory is the highest level of a discharge you can receive according to the DOC's guideline. The DOC's guideline actually specifically says that a participant will only receive a satisfactory discharge when they have successfully completed their individualized treatment program. So although Mr. Lopez only completed 4 months, DOCS itself did indicate that he received the highest level of discharge one can receive. With regard to why exactly that is exceptional, well, I would ask the court to consider all of Mr. Lopez's upbringing and the time that he went into prison. When the time that Mr. Lopez went to prison, he was 21 years old. He was battling a substance abuse problem. He has cognitive delays, and he was without the benefit of a mature adult brain. His clinical notes do all of the monthly evaluations that he received while he was in the sex offender treatment program, scored him as being highly motivated, and the notes indicate that he was actively engaged participant, as well as diving.
As to the seriousness of the crime, which is the third factor we would have to consider, right?
Right. Your Honor, Mr. Lopez does not.
Or his likeliness to reoffend, rather.
I'm sorry?
Go ahead.
Mr. Lopez does not contest that this is a serious crime. He has an accepted responsibility, and as is evidenced in Exhibit A, which is his letter to the board, has expressed an immense amount of regret, acknowledging that the pain that he caused to the complaining witness. However, I would just ask this court to consider the purpose of SORA, which is not to punish Mr. Lopez for a crime that took place a decade ago when he was under the influence and without a fully developed brain. The purpose of SORA is to protect the public, and in this case, a level 2 does not adequately reflect Mr. Lopez's risk of recidivism. Thank you.
Thank you. Good afternoon.
Good afternoon. May it please the court, Jamie Maston for the people. In light of the brutal and violent nature of the crime, along with the defendant's felony history, the SORA court here properly adjudicated the defendant a risk level 2 sexually
Well, what about the fact that your adversary is saying that a lot of his personal trauma was not accounted for by the risk assessment before the SORA court? Should we be considering that now?
Not at this moment, no, because as Your Honor also asked about, the seriousness of the crime and the grave harm that could result should the defendant reoffend are two of the paramount concerns within SORA, and those two factors easily outweigh any of the proposed mitigating factors supplied by the defendant. The harm in this case we know would be high because in this case we actually have a victim impact statement written by the victim who detailed the devastating effect that this rape had on nearly every aspect of her life, her professional life, her personal relationships, her sense of self and security. And I would note that the fact that she is still struggling so much with the lingering trauma from the rape, the fact that she felt as strongly nearly 2 years after the rape took place really shows the level of harm that could result should the defendant ever reoffend. For this reason, along with the calculated brutal nature of the attack itself, the moderate risk of offending that the defendant was assessed by the board as well as the SORA court is eminently appropriate in this case. This is not one of the rare cases in which this court needs to step in to issue a downward departure. Unless there are any further questions, I would rely on my papers and respectfully ask this court to confirm and affirm the judgment of the SORA court. Thank you.
Thank you, counsel.
Your Honors, I would just like to make 2 points. First, my adversary referenced Mr. Lopez's criminal history. Mr. Lopez had one youthful adjudication for a crime that took place 2 weeks after he turned 18. One of the points I referenced in my papers was that the risk assessment instrument in Factor 9 doesn't adequately consider a youthful offender adjudication. I am aware that the law has recognized that that is an appropriate use under Factor 9. However, this court does have the authority to consider this with in the third step of Gelati, that the risk assessment instrument does equate Mr. Lopez's youthful offender adjudication that took place at the age of 18 to an adult who committed a prior violent felony or a prior sex offense felony, and that is just not in accordance with the social science about youthful brains. Secondary, I would just like to point out, if the court will allow me, The lower court didn't actually make an assessment about whether Mr. Lopez had an exemplary response to treatment. Rather, the lower court summarily denied the defense application by saying that all of the factors were considered in the risk assessment instrument. And this court has recognized that an exemplary response to treatment is not recognized in Factor 12 as well as the guidelines. And I would ask this court to consider that in addition with all the other several mitigating factors laid out in my brief. Thank you.
Okay, thank you. Thank you both. YH Lex Estates versus Mayor. Good afternoon.
Good afternoon, Your Honor. Pankaj Malik from YK Law, LLP, for appellants Renee Bartolacci and Hermitage 1. May it please the Court. This appeal at issue deals with two questions: whether the lower court, Judge Cohen, erred in denying my client's order to show cause to stay the trial so that she could complete discovery, and whether Judge Cohen erred in requiring a bond equal to the face amount of respondent's claim.
The trial was complete in this case already?
There was a summary judgment motion granted shortly after the decision on this order to show cause.
So what does it matter whether he stayed a trial? There was no trial, so what's the difference? I mean, isn't this moot?
No, because even though he didn't stay the trial, he denied us the opportunity to complete discovery. He granted us leave to conduct discovery under CPLR 408, however, did not grant us the opportunity to complete it. We had less than 30 days to collect over 13 years of archived financial records so that my client could present a defense. The error.
How long had the case been going on at that time?
No, Your Honor, the case was going on against my client's husband and many other defendants.
Weren't most of the records that at issue your own client's financial records?
Her own personal financial records that were not at issue in the related proceeding that she was not a party to, she had no involvement with, except for the fact that there was a subpoena served on her that was quashed. She had no idea. She was kept in the dark.
The records that you were complaining about not having obtained, your own client's financial records.
Which had been archived, they were not available electronically. We submitted an affidavit that despite within the 3 or 4 weeks that we were served with the petition, my client tried to request those records, and she was advised by the financial institutions that these records have to be sent to her by snail mail in paper format. There was no electronic delivery possible because they had all been archived off-site. We explained that to the court. However, despite the fact that he gave my client the leave to conduct discovery, it was not a meaningful grant or an opportunity. There was no opportunity for her to exercise her due process rights and get the documentation that she required to present her defense. In fact, the court says at record page 263, lines 1 to 7, the court, well, I granted discovery. There was discovery. This is just a question of whether we should allow you to finish it. My clients were never parties to the prior proceeding against her husband. My clients were not judgment debtors at the time that this order to show cause was filed. My client asserted defenses, which the court below acknowledged and saw for the first time, based upon our pleadings, that there was a colorable claim of defense. Record page 251, lines 14 to 25. Your papers indicate, part of what is baffling to me is you submitted a set of papers where I finally start to see what the defense is. However, the court imputed the time that the case was pending against my client's husband to my client, as if they had some sort of symbiotic relationship that whatever complexities...
Don't you have to appeal the summary judgment determination and rather, isn't that the better vehicle to raise these issues in this case? Because this is really a motion to challenge the trial going forward. But what you're really challenging now at this point is the summary judgment determination, and that would be seems like it would be a much more appropriate vehicle to argue that summary judgment was inappropriate because there was discovery you needed or discovery that needed to take place that you didn't have time to do, and therefore summary judgment was an error. I I don't understand why this would be the vehicle for us to decide that in.
Well, we have preserved our right to appeal. We have not perfected that appeal yet. We still have the
Why
time.
should we entertain that in this proceeding, which was primarily about staying the trial, which never happened, as opposed to your perfecting the summary judgment motion, which would seem a much more appropriate place for this court to grapple with the issues that you're raising today?
Because this was the order that set up the domino effect. Because she could not get the time to collect the discovery, within less than 4 or 5 days, summary judgment was awarded against her.
Right, but that's what you're challenging, the summary judgment. You're not now really challenging the failure to stay trial, you're challenging the summary judgment determination.
Well, that's as part of the other appeal. This one, we felt that the court erred in denying us the opportunity to complete discovery and setting an
Before trial.
Before a
Okay, to
trial that
complete
never
Before trial.
happened.
Right, to, and to
never
extend time to do the discovery, to complete the discovery. It was just, his grant of the 408 leave to conduct discovery was just, an exercise in futility because there was no intention.
Well, don't things hinge on whether you can effectively reverse the grant of summary judgment, which is going to be based on the documents that were before the court at the time the motion was granted?
And we did file the appeal on this, really based upon the language in the order, which basically said she had months to prepare this defense when she was never even a party to the action. We believe that was reversible error. We filed and perfected this appeal.
You can't, with whatever discovery you come up with now, upset the summary judgment. I mean, that issue is going to depend on what you had at that time. On appeal, the record on appeal is going to be what was before Supreme Court.
Right, and that's the problem. We didn't have anything because we weren't given the opportunity. Summary judgment was granted literally within days of the denial of our request to complete the summary judgment, the discovery.
Okay.
I just want to raise one.
Why don't you do it on rebuttal? Okay?
Sure, no problem,
Thank
Your
you,
Honor.
counsel.
Thank you, Your Honors. Ms. Bartolacci never conducted any discovery, never attempted to conduct any discovery. If you look at the affidavit that was submitted with the order to show cause, the defendant herself claims that she called her banks on the phone, not through her lawyers, not through a subpoena, to get bank records. During the nearly 3 months that the special proceeding was pending, and as you know, special proceedings are often decided summarily, her counsel could...
Well, if they're your records, I mean, is there anything wrong by calling your bank and saying, I want to get these records, how do I have to go about doing it?
Nothing wrong with it, Your Honor, but if you want to conduct discovery in a litigation to get documents in time to meet a court deadline, you issue a subpoena. You don't pick up the phone and call. That never happened here. Regardless of
My point is not really discovery. I mean, our claim is that she wasn't given enough time to follow through with this process with the banks, but it's not a matter of discovery. It's her obtaining her own records.
It's her own records, so the explanation's a little hard to follow that she couldn't get them. But there's a process with a subpoena. You can get the documents in 20 or 30 days through a subpoena, through a legally enforceable process. Calling up on the phone is not going to do it. Regardless of the correctness of that aspect of the decision, this appeal should be resolved on the question of the bond, okay? The judge agreed that he would delay the decision and the trial and allow more time for discovery, even though Ms. Bartolacci never served any discovery during the 60-so days that were allowed, if a bond was posted. And he did that because the judge knew that these defendants were spending $150,000 a month on rent at a Miami Beach property. They were wasting away the money very quickly, so the judge wanted to move quickly. He'd seen the evidence. And so he said, yes, I will allow you to take this discovery if you post a bond. And the response from Ms. Bartolacci, may I conclude, Your Honor?
Yes.
Was, oh, well, I've already got some assets that are secured because we'd found a bank account that we successfully secured pre-judgment. That bank account had $1.5 million in it. The amount of the voidable transfer was $13 million. And so the explanation from Ms. Bartolacci that there was sufficient security because of the 1.5 doesn't make any sense. Thank you.
Okay, thank you.
Thank you, Your Honor. Subpoenas, even if we had
Can I ask
served...
you a question? What is the specific part of Justice Cohen's order that you're appealing from?
the entire order, Your Honor, not just the bond, but also the fact that she was required, she was held to a standard that she should have been preparing for her defense months before she was even sued.
What is it that he ordered that you are objecting to?
The language that she should have had access to her own records, despite the fact that we made
That's a finding, that's not an order that tells her to do something. What is it that you were ordered, that your client was ordered to do that you're objecting to?
He denied our request to extend the time for a brief period of time, not indefinitely, as the respondent's brief said, just a couple of weeks so we could compile the records, get a financial expert to show that her contributions to the purchase and construction of the property that was sold was part of her defense, that some of that money was hers, not all of it was available for the defendant, for the petitioner to have turned over. As far as the bond issue, the property was sold and the funds were transferred to my client a year before this order to show cause was heard. What was the exigency that we couldn't have gotten 3 or 4 more weeks to complete the discovery? It was highly prejudicial to my client for the court to force her to put up a face amount of the judgment, $12.5 million, when she wasn't even a judgment debtor. She had never been involved in the prior proceeding. She had been in the proceeding for 30 days, and that's the basis for objection, and we request that the order be reversed. The balance of my arguments, I rest on my papers unless the court has any other questions.
Thank you, counsel. Thank you both. And the last case for oral argument is Arch Insurance versus Doc Network. Good afternoon.
Good afternoon, Your Honor. May it please the court, Sean Keeley on behalf of the appellant Arch. And it wasn't lost on me that you announced we're the last case of the afternoon, so I'll try to get right to it. And this case from the very outset was about the defendant's mis-selling of Arch Insurance into the COVID-19 pandemic. And what the trial court got fundamentally wrong is dismissed the entire action as to the mis-selling. What the trial court did, and there are 2 orders on appeal. I'd like to focus mainly on the order dismissing the breach of contract claim as to any policies issued prior to March 20 of 2020. The trial court originally dismissed the original complaint saying Arch had exclusive authority to bind the policies, allowed an amended complaint. It found on the motion to dismiss that's before Your Honors now, found that, in fact, Arch adequately pled that the respondents had the authority to bind Arch to those policies. What it went on to say, though, is that because Arch pled that it said the CFAR coverage would be unavailable after March 20, every policy sold prior to that is out of the case. That misses the entire point of the case, and it also misses all of the allegations immediately preceding what the trial court relied upon. Those allegations were that as of March 8, 2020, Arch said, 95% sure we're taking CFAR out of the market, said, quote, pull all details on it from your marketing. On March 18th, Arch told the defendants, quote, CFAR gotta come down ASAP. They responded, yes, we'll confirm. What they did was the opposite. And that—
What's wrong? The way you just described it, it sounds March 20th is the date that the instruction was do this now, and March 18th. So what was wrong about the court's decision that there's no claim for policies before that date?
Because the defendants had the authority, the discretion during that time period to sell the policies and bind Arch. It's important to keep in mind
Can I
that
just
the
ask
CFAR—
one question before you go on, just to piggyback? So are you specifically pointing to the time period from March 8th to March 20th, or sometime before March 8th?
Justice Pitberg, you have it exactly right, between March 8th and March 20th.
So that's the first indication that you alleged in your complaint where there was correspondence about holding back or pulling down or not selling these policies.
Correct. And among the contractual provisions alleged in the complaint were that Arch, the defendants had to get Arch's approval for their marketing of the policies. Arch said, take it down. They ramped it up. In fact, as pled in the complaint, when they were told on March 18th that the CFAR coverage was going to be unavailable in the market from March, what the defendants did was told people, March 20th is the date. You should buy it by that date. That was a fundamental breach of their obligations under the contract, and we cited for the court the multiple decisions about how duties of good faith and fair dealing work.
So where do you, what's your breach of fiduciary duty claim?
As this court decided in Richbell, these facts can sound both in breach of contract, breach of the duty of good faith and fair dealing, as well as fiduciary duty. Because of the fact that these parties had been in a contractual relationship for 3 years at that point, with this broad discretion, that gives rise to fiduciary duty.
What you're saying is that early on in March, they were under a contractual duty not to continue selling the policies.
Correct, Your Honor. That they were told that the policies, that they should take down the advertising as to this particular type of coverage, the CFAR coverage. There's other coverage that was still available. They were told to take it down.
That's not an issue here, right? The other coverage is not an issue, right?
Correct, because this is the one that they pumped up.
But it's your point that as of, did you say March 9th, is it, or?
As of March 8th, they began telling the defendants to
March
take it down.
8th, that as of March 8th, they breached the contract by continuing to sell these policies.
And continuously breached it between that period and indeed a day or two after March 20th, because once they opened the floodgates to try to get them in under the deadline, a few were sold after that.
So your breach of fiduciary duty claim relates to the same period?
It does, Your Honor.
And why wouldn't it be duplicative?
Well, in part, it's not duplicative because Justice Ostrager dismissed the breach of contract claim.
But if the breach of contract claim was restored, then you would be satisfied with having that claim?
We would, Your Honor, in part why I focus so much on that order. We could get complete relief if we had our complete contract.
So the thing is, if the breach of contract was limited till after March 20th, there's kind of not, almost very little left after March 20th is what you're saying, because a couple days after that, it did shut down, right?
Exactly, Justice
So
Kavanaugh.
there
It
was
wasn't
just,
available for
so
anyone.
there was just, I see in your, well, I have a copy of the proposed first amended complaint, which I don't think you were not allowed to amend that complaint, but a lot of it is the same as what was in the original claim. You just added some additional things, but it was in the original complaint that starting March 8th, there was correspondence back and forth. So this whole case really is dealing with policies that were issued from March 8th till a day or two after March 20th. So if we cut it at March 20th, that's not much of your case left, is what you're saying.
You have it exactly right, Justice Kapnick, that here,
Go ahead, answer the question.
that here, the defendants in that period between March 8th and March 20 plus a day or two abused that discretion they had to do exactly what Arch told them it didn't want done.
And we're talking about something like 400 policies that they sold?
I believe more than 400 in that period, but yes, I mean, radically more than that had been sold at any time prior.
Resulting in losses of like $1.5 million to?
Yes, over $1 million what we alleged.
Okay, thank you. Let's hear from your adversaries, and you'll have a couple minutes to respond.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the first named defendant, Doc Networks. I'd like to take a step back for a moment, okay? Because we're here for one reason, which is that the plaintiff made a bad business decision, okay? It's only a bad business decision. In retrospect, it was a very confusing time. We all remember that. They continued to bind policies until March 20th. They didn't have to, okay?
So are you saying that you could have sold these policies and they could have not binded them during that period of time?
Exactly, exactly. And if you look at the language of the contract.
Okay, go ahead.
If you look at the language of the contract, it's there in black and white. It says, only Arch.
If they told you to stop selling the contracts, even if they had the power, even if they could have, wouldn't they still have a basis to have a claim against you?
I do not believe so. Again, the contract is what governs. The contract says.
You were the producer, right? Your Camp Docs, you were the producer.
Camp Docs is the producer. They are the, let me put the exact language.
You're talking about the producer agreement.
It's right. When I say contract, I am talking about the producer agreement.
That Roan Wright broker agreement between you and Arch, is that what you're
Right.
talking about?
And when you go to page 173 of the record,
Okay.
okay, it says only the company, Arch, has the exclusive, and the word is exclusive, authority to bind coverage. Okay, and just in case it's not clear what exclusive means, down further in the clause it says, you, the producer, meaning Camp Docs, has no authority to bind the company. That's about as clear as you can get, and that's why the court below dismissed the first complaint. Now, the plaintiff then moves to amend, and under the very liberal pleading standards in the state, the CPR says leave to appeal shall be granted. So it's granted. But then the substance of it is challenged again. And the court says, well, now you've alleged some additional facts. You've alleged the fact that they keep selling after March 20th, which was the cutoff date. So I'll allow those things to proceed. But the court never reneges on its original finding that the rest of it is defeated by the language of the contract itself.
And what you're saying, it's that a paragraph that you just read on page
Yes.
173?
Which says basically,
So you're telling me that even though Arch told you, stop selling, things are looking bad here, we're going to pull this down, you go and continue to sell, but they continue to bind it, and so the whole procedure
so I'm saying
goes?
that, look, part of any case, obviously, is not just cause, it's effect. There has to be damage. The only reason there's damage is because they continued to bind the policy. And again,
So your defense to this is that maybe we didn't listen to them, and maybe we did wrong, but it all didn't matter, because nothing forced them to accept these policies. They could have just rejected them.
that's certainly part of my position. But again, the other thing to remember is that March 20th is that there's communications beforehand. There's no question that there's communications, some with the very people I represent, some with the people the
Right,
co-defendant
starting March
represents.
8th, right?
Right. And 2 days before they give the instruction, in 2 days we're going to stop this. Okay? They didn't say on March 18th, stop it now. They said in 2 days.
On March 8th, when the communication started, was there any indication as to what date they would stop it, or was it just an open-ended, this is what we're thinking about?
Right. I mean, there was again, we all remember what it was like. There was a trend that was becoming apparent, okay? But nobody was clear what was going on. I remember around that time, being told, go buy 2 weeks of groceries because you're going to be shut down for only 2 weeks. Nobody knew what was going on. We were told to stop on March 20th. We stopped on March 20th. And that's why in the last decision that's part of this record, the court says, I'm going to allow these, claims with regard to post-March 20th.
Did your client sell any
to continue.
policies after March 20th?
Hmm?
Did your client attempt to sell any of these policies after March 20th?
No. And that's why
So
I think, that hasn't
What
gone.
does that mean, that the court said the claims could go forward for policies sold after March 20th, if there are no policies after March 20th?
If the plaintiff can prove that there were policies that we sold after March 20th, that will
You're saying you
proceed.
didn't even attempt to sell any after March
That-
20th. You
and-
listened to the
and-
instruction and stopped selling policies.
Right, and if that proof is otherwise, that will go
So
to
what
trial
about-
and the plaintiff will be entitled
Okay,
to
so what
damages.
about those other causes of action, which, the breach of fiduciary duty and the unjust enrichment and the fraud, which is against one of you, and
Yeah, I mean, look.
What about, those are allegations that in the event the contract doesn't seem to work, then we have these equitable causes of action. So what about those? Aren't they pled appropriately?
I know my time is up, but let me, can
Oh,
I
I
just
want you
very
to
briefly?
answer. I'm in charge of that. I'll walk away.
There's, our briefs very clearly go through each cause of action and what the elements of each cause of action are, most of which require something independent of the contract, which is not shown here, okay? And as a matter of fact, that you can pose this as a but-for question, okay? But for the language of the contract, would any of these causes of action exist when any of these damages exist? And I think the answer is no. That's how inextricably bound they are.
Your adversary says that this is about breach of contract.
This is a breach of contract case. And the contract says what it says about the ability to bind, which rests
Counsel, I
exclusively on their
I have
shoulders.
another question. I'm a little confused at this point. You're saying that as soon as they didn't tell you to stop selling until March 20th, and as soon as they told you to stop selling, you stopped selling?
On March 18th, they said, these policies are pulled from the market as of March 20th.
So if that's your position, that they told you as of March 20th, stop selling, and you stopped selling as of March 20th, why did you have to make that whole argument about no authority to bind? Because that would really be besides the point if your primary argument is they told us to stop by March 20th, we stopped by March 20th, and therefore there can't be any liability.
Well, look, I'm just dealing with the order that's now on appeal, which is that allowed the claims post-March 20th to proceed, and they are proceeding. I think there's deposition scheduled
You're saying
next month.
you didn't issue any policies after the 20th.
And I believe that's what discovery will show.
And if it doesn't, you'll be responsible for them. Well,
That-
you don't have to.
Again, I don't know what the evidence is going to show because that discovery hasn't
I mean,
taken place
that's
yet.
his claim, that then you're responsible for them.
Right. I think his claim is, well, under the current court order, if there's discovery that shows we sold policies after March 20th, they will claim that we are responsible for that.
I didn't mean
Although
to-
even then, I would argue that the binding language of the contract would defeat that. But that's an argument for another time.
I didn't mean to ask you for a concession.
Yeah, no. Well, I'm not conceding anything. It's like I said, I think even if the evidence were to show that, which it won't, the fact is that even
That's- we have
then,
another-
I would have the ability to move for summary judgment based on the language of the contract.
Okay, thank you. I think we got your point. We'll hear from your co-defendant. Good afternoon.
Good afternoon. May it please the court. My name is Victoria Lieberchuk from Farrell Fritz, and I represent the respondent Camp Assure LLC. Boiled down to the simplest terms, we are here today because Arch wants a do-over. In March of 2020, Arch knew the state of the world. They knew about the
No one
development.
really knew the state of the world, I hate to say, but I don't know if I buy that. Go
No
ahead.
one knew the impact.
Let me just ask this question. So your understanding between the period of March 8th and March 20th, was that just we're thinking about it, this is what's going to happen, and then on March 18th when that email went out that said, do this as of March 20th, is that the defining moment for you? But what about everything that came before that?
Yes, that's the defining moment, and that's what they allege in the complaint on page.
No, but honestly, I have the complaint in front of me, and I don't think that's not all they allege. Anderson, who I think works for you guys, he's the owner of Camp Assured, responded by indicating that Camp Assure would pull all CFAR details from the marketing and promotion of Arch's program cancellation insurance policy. So you were going to pull it. You were having these discussions that we see it's coming, we're going to pull it. So it's not like on March 18th, all of a sudden they came up with this idea that there's a problem. You've been having conversations with them since March 8th. That's what the complaint says.
Absolutely, that is what the complaint says, and we were having discussions as of March 8th. On March 8th, according to the complaint on page 341, Arch advised that there was a 95% chance that the CFAR policy would come down. Not, please stop marketing the policy on this date. They were just advising them that they were considering doing that. So Camp Assure continued to market the policy as they saw fit.
And
On
there's
March,
no question that Camp Assure could not bind the policy.
Camp Assure cannot bind the policy. There are no allegations that they can. In fact, Camp Assure was the middle person. Camp Assure did not go out there marketing the policy to the camper families. What Camp Assure did was introduce prospects, travel retailers, such as my co-defendant Camp Docs, to Arch. That is what Camp Assure did. But irrespective of that, all that Camp Assure and all that the respondents did was follow the instructions from Arch. Arch said on March 18th, effective March 21, there should be no further policies out there. Effective March 21st. There's no question that prior to March 20th, Camp Assure and Camp Docs had permission from Arch to continue marketing the policy.
So are you also saying that there were no policies issued after March 20th? So to allow them to recover for those policies, they're non-existent. What's the point of that?
I'm saying that Arch may allege that there were policies bound after March 20th, and that's an issue for discovery and not in the record right now. That part of the claim is continuing. What I'm saying is that Arch has now manufactured a breach of an implied covenant of good faith and fair dealing argument for the first time on appeal.
if you look at the original complaint, the proposed amended complaint, and the actual amended complaint, they're not alleging that we acted in bad faith. Now, in order to expand on their only surviving claim for breach of contract, they're trying to manufacture this claim. And if you look at the complaint, in order to allege an implied covenant argument, Arch has to allege that Camp Assure either prevented the performance of the Roam Right agreement or withheld Arch's benefits under that agreement. That is not what they have alleged. So we ask that this court affirm the lower court's decision in limiting the breach of contract claim. With respect to the quasi-contract claims for breach of fiduciary duty and unjust enrichment, they fail as well, and the lower court threw them out because they're entirely duplicative of the breach of contract claim. Unjust enrichment, under the Court of Appeals matter Costello versus Verizon, has held that unjust enrichment is not a catch-all that survives if all other claims fail. Even if the court dismissed the breach of contract claim in its entirety, which it didn't because it still remains for policies issued after March 20th, it does not, you can't have an unjust enrichment just because another claim fails. And with respect to the fiduciary duty, besides the fact that it's entirely duplicative, there is no fiduciary relationship. If you look at the terms of the contract on page 117 of the record, I see that my time is up.
No, please finish.
Thank you. The contract says Camp Assure is not an agent of Arch. It says that Camp Assure is an independent contractor. If we were to ignore the language of the contract, there would be no point in entering into these contracts. Thank you.
Okay, thank you.
If I may briefly?
Yes, so counsel, I wondered what is your response to what we've heard here from the defendants, that you had the ultimate responsibility pursuant to the contracts to bind these. So even if they went out and got lots and lots of people said, oh boy, this is a great insurance for me now, my kids aren't going to be able to go to camp this year maybe, you had to ultimately bind them, and so whatever damage you suffered was because you bound the contract, not because they sold them.
Your Honor, directly I would say they're wrong about that based on the law of this case. In fact, in the order that's on appeal, page 32 of the record, Justice Ostrager said that he granted, quote, the court granted the motion by Arch for leave to file an amended complaint alleging that Camp Doc and Camp Assure had actual and apparent authority to bind coverage as agents of Arch, and that they did that.
But does the contracts, the broker agreement and the producer agreement, do they say something different? That's what your adversaries say.
Yet my adversary continues to leave out the very end of the clause that they quote that says, except as otherwise provided herein. And for example, as to Camp Doc, the contract specifically provides, which is noted in the brief, that they act under Arch's license. So that means they're allowed to market, sell, collect the premium, and that's binding the policies. Notably here.
Where's the language in, or the evidence that you gave a clear instruction before the 20th that they should stop signing the policies? There was clearly dialogue going back and forth, but where is there any indication that you said before the 20th, stop signing the policies today, which is what your whole argument is based on?
Justice Kern, I'd answer that, I think, in 1.5 ways, which is the CFAR coverage at issue here is one aspect of coverage that could be put on a number of policies. So where it is in the record is each place we talked about in my opening argument from March 8th forward where they said CFAR coverage got to come down, stop marketing it. Because they could sell other Arch policies, just not with that coverage on it.
Then why issue an effective date of March 21st?
Justice Pittsburgh, that effective date was not for these defendants. That was for the whole world. What Arch said is consistent, and I'd refer you specifically look at that paragraph in the complaint. They say, CFAR will not be available after March 20th. Consistent with others in the industry, it's not designed or rated for this. So what they're saying is that product ain't available for anyone.
As I understand, you're claiming that before March 18th, you told them they should stop selling these policies.
That before March 8th, on March 8th, on March 12th, on March 18th.
And what is the evidence to review that you point to in support of that?
The complaint actually contains quotation marks about C4 got to come down. Those are from emails. Again, they're allegations, so we're on a
Said
motion to
pull
dismiss.
all CFAR details. It doesn't say next week, it just says pull all CFAR details from the marketing and promotion.
Yes, and the respondents responded, will do that. And instead, as alleged, they did the opposite and tried to market as many as they could before March 21st.
And what's your response if they didn't have the ability to bind, why they should be liable, since it was ultimately in your hands to reject those policies?
That also is 1.5 responses, and it's also pled that, as it's a contractual provision, that each month they had to report to us. So we're talking about 3 weeks in which Arch has no idea who they're selling these to. And the way they're sold is through the CampDoc website. The camper comes, signs up, the camper gets confirmation that they have a policy. So March gets a list of policies, hundreds of policies sold.
So that comes back to your saying that they could bind the policies.
As did the Supreme Court said, that we adequately alleged that they could bind the policies. And they did, because we got a long list around April 8th of all the policies that all these campers had from Arch. And I'm long past my time, but I want to make sure I answer.
No, if we keep asking questions, that's because we want answers. Okay, thank you all very much.
Thank you, Your Honor.